I came across a report yesterday, quite late actually, following a webinar that the National Prosecuting Authority had in the Northern Cape. It was primarily around issues of maintenance, and it came to light that my siblings, or your siblings, could literally claim for maintenance against you. That family member who's claiming support must be unable to maintain themselves, reportedly, and the family member from whom maintenance is being claimed has to be able to afford it. Joining me on the line is Senior Maintenance Prosecutor at the National Prosecuting Authority here in Cape Town, Advocate Deon Ruiters. Deon, a very good afternoon and welcome to the show.
Good afternoon, and good afternoon to your listeners.
Has this been in place for some time? Why am I learning of this for the first time yesterday, I wonder?
It has been in place since 1938. In 1938, there was a case, Worthington versus Stanley, where it was already mentioned. And then a few years later, in 1972, from Phelan versus Sam, and Judge John Murphy recently in a case in the Gauteng High Courts also mentioned it in Langa versus Road Accident Fund. So it's a long-term decision or policy that we in the Department of Justice and in the National Prosecuting Authority apply whenever we deal with matters involving a indigent person, a person that can't take care of himself and his parents are not over there to assist him. Then we can go for the other siblings, that is your brother, your sister, or a stepbrother or stepsister, that we can then request to assist with the indigent person.
How often does this happen in your courts, Deon?
It doesn't happen that often in the Western Cape, where I am based. There are 57 courts in the Western Cape, and of the 57 courts, over the last 8 years, I haven't stumbled upon any of those type of cases. In the other provinces, there are 453 courts in South Africa, maintenance courts in South Africa. And it's here and there that we will get a case where a person will come to one of the 453 courts and request, please help me, I'm indigent, I can't afford to keep myself alive or sustain my own needs. I've got a brother or a family member that can assist me. Please help me to ask my brother to help me. It happens, but it's very, very seldom that it happens in the 453 courts in South Africa.
Would they have to prove that they have tried everything possible? They've gone to school and they have not managed to pass. They have gone to, SASSA to apply for any kind of support before they come to me.
Yes. I do not want to startle the listeners. I think your first point of entry will be your biological parents. If your biological parents cannot assist you and is receiving a SASSA grant, then your next line will be your grandparents. After your grandparents is only third in line, then you can go to your other siblings. But then it's not just a mere sake of saying, okay, my brother is a senior prosecutor, advocate in Cape Town Court, and therefore I can ask him to now all of a sudden sustain me. There must be a need, and he must show that he is not unwilling to work. He's willing to work, but he can't in our modern financial, sociological climate, cannot get any type of useful employment, and therefore, as a last resort, he would like his other sibling to assist him in his specific needs that he have in society.
To what amount, Deon? I mean, is there... I don't know what the sort of grants are that the social services is issuing, 2.5, let's say, for senior citizens. Is that the level to which you pay for them? Or can they say, well, I grew up in a household where I used to eat so many portions of meat a week and I want to be able to live like that again?
Yeah. What we do is we need to first determine the specific need of the person, and he need to show that this is what I need in order to survive. It will be basic needs, not extravagant needs where he grew up in Bishop's Court and therefore would like to have the same style of living and want the sibling to now all of a sudden also put him in a house in Bishop's Court. It's not like that. It will be his basic needs to survive and to be able to take care of himself. I'm dealing with a case now where a mother is applying for maintenance from her son, and they had a specific type of living that you will say that they were privileged, and now she is living in a type of a foster type of not a foster old age home, and now she have a need in order to pay at least for basic food at the old age retirement village. And that's where I got involved and asked the adult sons of hers if they can't assist. So it will be limited to your basic needs and not extravagant needs where I am indigent, but now I want to play violin or I want to go and play water polo. Not those type of needs. It must be basic survival needs. That's what we will look at.
Am I allowed to refuse? Even if Advocate Deon Ruiters is going through the courts to try and get money for my brothers from me?
You can try to refuse, but if it's Advocate Deon Ruiters, you are going to pay something. Not what you, I'm not going to take your whole salary, but I will ensure that based on the blood relation between you and your sibling, you will be able to assist him in one way or the other, unless you can show to me that I cannot afford it. I've got so much expenses myself that therefore I cannot afford it. But a basic refusal is not going to work. Because of Section 2 of the Maintenance Act says that any type of a relationship, if there's a blood relation between you and the other sibling, then I will hold you accountable for it. And if I can just quickly say, we even extend it now to step-parents. If a stepfather is taking care of a household and he somehow set the standard that this is what I am making my children and stepchildren accustomed to. Judge Daniel Tulare over here in the Western Cape said that step-parents will be held liable to maintain this lifestyle that the stepchild is used to while that family was still intact and one family. So it's not just in siblings, but also in step-parents. I've dealt with cases where I held stepfathers liable, and we do it in our maintenance courts. The 57 courts in the Western Cape, no sibling will get away with it.
Deon, I am flabbergasted. But by the way, by extension, does that mean that if someone has successfully sued for child maintenance, that child maintenance doesn't have to stop at the age of 18? For as long as they can show that even an adult child, by law, is still in need of your maintenance and support, that will continue beyond 18?
Yes, there is a Supreme Court of Appeal case that was decided 3 years ago, 2023, Z versus Z, where the Supreme Court of Appeal already set the standard that where an adult child over the age of 18 needs financial support from his family, despite the fact that he is now deemed an adult in terms of Section 17 of the Children's Act, we will hold that person liable. So if our listeners out there is listening, please do not think that maintenance stop at the age of 18. It will continue in terms of the Supreme Court of Appeal Z versus Z case. And there is a George Circuit case of Judge Vincent Saldana and Judge Nathan Erasmus, DWT versus MT, where they also found that maintenance do not stop at the age of 18. It continues beyond of the age of 18. In the Z versus Z case, the children were 23 and 25. In DWT and MT, the children were over the age of 21, and the parents were still held liable for maintenance in both those cases.
George has just had a child and he's literally just put his hands over his head because he's realizing that the responsibility will extend beyond the age of 18. He's going to be a present father, I'm sure. Deon, thank you very much for that. Advocate Deon Ruiters, a senior maintenance prosecutor at the National Prosecuting Authority here in the Western Cape.